Welcome to the Federalist Society Supreme Court Preview. My name is Bob Barnes. I cover the Supreme Court for the Washington Post. And we have a great panel for you this afternoon, otherwise known as lawyers who don't have a client in the Clean Power Act case, which I guess is in the middle of its marathon hearing right now. I wanted you to know that the hashtag for this event is FedSocEvents. I had to learn from my law school daughter that FedSoc was a thing. I didn't know that. And we also have a virtual audience out there because we're live streaming on the FedSocBlog, YouTube, and Facebook Live. So we hope to make this a very interactive afternoon as we talk about the Supreme Court, something that did not get any attention during the presidential debate last night. But, you know, there are two more. There's still a chance for them to remember there's a vacancy there. And so let me introduce the panelists, and then we'll go back to them to have some opening remarks and to talk about a few of the cases that we have. I'm doing this in order of the way they are presented on this bio list that I have. So first I want to talk about Tom Goldstein, who is a partner at Goldstein Russell. Tom has argued 28 cases before the Supreme Court, including matters involving federal patent law, class action practice, labor and employment, disability law. In addition to practicing, Tom teaches Supreme Court litigation at Harvard Law School, and he used to teach at Stanford Law School as well. At the Supreme Court, Tom litigates and advises clients on a broad range of issues, as you've heard. He regularly litigates and lectures on questions of federal patent law, frequently advises them on legislative matters regarding to the First Amendment, and as some of you might know, he's big on poker. So he regularly represents parties in questions relating to the game of poker, including its lawfulness as a matter of federal and state law. More important to those of us who cover the court, and probably to all of you, Tom is the founder and publisher of SCOTUSblog, which in 2013 became the only weblog ever to receive the Peabody Award for Excellence in Electronic Media. It also won Society of Professional Journalists Sigma Delta Chi Prize for deadline reporting. It is really indispensable to all of us who cover the court. Before his current law firm, Tom worked at Boyce & Schiller and Jones Day, and he founded the Supreme Court practice at Aiken, Gump, Strauss, Hauer, and Feld. But now he is back to Goldstein and Russell, and we regularly see him arguing at the Supreme Court. Nicholas Rosenkranz is a professor of law at Georgetown and a senior fellow in constitutional studies at the Cato Institute. He teaches and writes about constitutional law and federal jurisdiction, and is currently developing a new theory of constitutional interpretation and judicial review. The first installment, entitled The Subjects of the Constitution, was published in the Stanford Law Review of May 2010, and it is the single most downloaded article about constitutional interpretation, judicial review, or federal courts in the history of SSRN. The second installment in May 2011 was called The Objects of the Constitution, was also in the Stanford Law Review. He clerked for Judge Frank Easterbrook on the Seventh Circuit and for Justice Anthony M. Kennedy. We'll be looking for him to explain Justice Kennedy to us. I know he'll want to. And he is also a member of the board of directors of the Federalist Society. Carrie Severino is the chief counsel and policy director of the Judicial Crisis Network. In that capacity, she briefs senators and congressmen on judicial appointments and she appears on all matter of media and regularly speaks with us lowly scribes as we talk about Supreme Court and judicial nominations. She was previously a law clerk to Justice Clarence Thomas and was also a clerk to Judge David Sentell. She's a graduate of Harvard Law and went to Duke University, the beloved Duke University by all. We also have with us George Terwilliger. He is co-head of the white-collar practice at McGuireWoods. He leads the firm's Strategic Response and Crisis Management Practice Group. As I'm sure you all know, he is a former federal prosecutor in the Department of Justice during 2 administrations. He also was involved in with the Bush-Cheney legal team in the 2000 Florida vote recount and has served as special outside counsel to a Senate committee investigating vote fraud allegations. In his 10 years as a frontline federal prosecutor, he handled hundreds of investigations, trials, and appeals, including in white-collar and national security cases. Ronald Reagan appointed him as a U.S. attorney, and he continued to serve in the Deputy Attorney General and as Acting Attorney General during the George H.W. Bush administration. So, smart people, a lot to learn from them. We're going to get started, and we'll hope to leave plenty of time for your questions. Carrie is going to start us off with a view of the term and also talking about one of the big terms of the case, Trinity Lutheran Church v. Pauley, which was granted last January before Justice Scalia's death and has still not been scheduled by the Supreme Court for oral argument. So Carrie will tell us why that is.
I wish I knew. My assumption, welcome everyone. I think it's an interesting term to be discussing here because, as many of you know, we have fewer cases than usual on the docket with only 8 justices, and you still need 4 votes to grant cert. I suspect that plays into the fact that there's just only 8 people you can garner those 4 votes from. Also, I think the conventional wisdom is that the court is attempting to take cases that aren't hitting as many of the hot button issues, certainly as the last couple terms have hit, if they can help it. So sometimes they, like the immigration case, I don't know if they could have helped take a case like that. But I think when they have the opportunity, they may be hoping to wait on some of those cases until there is a 9th justice and in the hopes of not having a 4-4 split. That said, last term, even not having that foresight to be able to plan for a non-controversial docket, they did only end up with 4 cases that went 4-4. There were some really interesting and creative attempts at finding unanimity, even in hot-button cases like the Little Sisters of the Poor. So I think this term, I actually would expect that even though we have the full term with only 8 justices, I think what I would predict is that there probably won't be a replacement there by the end of the term. But I wouldn't predict we would have many more cases that go 4-4, in part because I think the justices are carefully trying to maintain the consensus when they can. Maybe they'll be the only branch of government that achieves consensus this year. So at least we've got 1 out of 3. So the case I'm talking about is the Trinity Lutheran case is a case that does implicate some of these hot button issues to a certain extent. Religious freedom has become a real high salience issue lately. But in this case, I think mercifully it doesn't interact with any other major issues. It's not interacting with contraception. It's not interacting with gender identity. It's interacting with playgrounds and playground equipment. And I think that's something that a lot of people can get on the same page about a little bit more easily. This case deals with a program that Missouri had that would it would reimburse schools or organizations that have playgrounds with the funds to replace their current flooring material with a rubber recycled rubber tires. So it would be a softer surface, and it would help also keep tires out of landfills, and also I think they were encouraged to have programs educating the children about recycling, so trying to have a message there as well. So there are sort of a few different goals to this, but really I think the biggest one would be helping children have a safer playing surface. Trinity Lutheran Church has a preschool and daycare center, and they applied for a grant under this program. There were 44 applicants, and according to their neutral criteria, which ranged from everything from did you complete your application to, how did your project plan look like, and did you have that educational program in place to teach about recycling, et cetera. They were actually ranked 5th among those 44 schools in terms of desirability for them to have the grant. And the state ended up giving out 14 grants, but nonetheless, Trinity Lutheran did not get one of those grants, and that's because Missouri has a provision in its constitution that's called a Blaine Amendment, and it provides that no money shall ever be taken from the public treasury, directly or indirectly, in aid of any church, sect, or denomination of religion. And Missouri Supreme Court had interpreted that as I think the text kind of makes clear to say that providing this to the funding for this playground to the school would violate Missouri's Blaine Amendment. Now, the Blaine Amendments are actually something that are in, I think, at least 30 different state constitutions, and they arose in the middle of the 19th century. There was a man named James Blaine who is part of was really kind of a broader anti-Catholic movement, was attempting to get a federal constitutional amendment passed to keep federal money from ever supporting any sectarian schools, which was really a code word, particularly at the time, for Catholic schools, because from our current sensibilities, the public schools in general would have looked very sectarian, I think, to us today. They had the mainstream Protestantism was very much involved there, but. So these amendments did not succeed at the federal level, but they did succeed in many states, in particular Western states that were coming up with their constitutions around that time. So Missouri is one of the states in 1875 that had this provision, and the challenge here is that this creates a situation where a generally acceptable, available public program is not available specifically because of the religious status of this church. So you've excluded on the basis of religion an organization, and it's clear that under the federal constitutional establishment clause, providing tires in these circumstances would be for the playground would be fine. It doesn't. You're not providing Bibles. You're not providing hymnals. You're not providing anything that actually, religion textbooks, for example. This is something that really is aimed at the safety of the children, and in fact there's many children other than just the school children who are using the playground that people from the surrounding area use it as well. So the question in this case is going to be, the federal establishment clause doesn't mandate it, but does the federal free exercise clause prohibit this level of, I would say, not even merely anti-establishmentarianism, but hostility toward religion in a state constitution? If you took the words to their logical conclusion, you really could imagine that if a state wanted to, they could go so far as to say, well, it says directly or indirectly we cannot aid any church, sect, or denomination of religion. So you could say we're not going to repair the streets and sidewalks in front of any house of worship because it's going to enable people to get to the house of worship. You could refuse to send the fire or the police to houses of worship, even though they might come to the aid of people in the home built next door. You could, as I think is brought up in the briefs, you could say you have HOV availability where you get free if like on 495 where you get HOV 3+3, and we're not going to give that if it's the church van bringing kids to a church event, but you can get it for all other things. So the extent to which that can be stretched is pretty significant. The Supreme Court in the past has upheld Blaine amendments, at least as applied to, for example, funding seminary education. But I think this question is going to be a really interesting one because it's so divorced from the actual religious practice or education here that I think this may be an opportunity, I hope, to maybe get everyone across the aisle and across the bench on the court this time to be able to say, well, here's a cause for religious freedom that we can all get on the same page at and at least as a kind of lower threshold of what states must do in terms of non-discrimination toward religion. So.
Now, that's the most optimistic I've heard anyone be about getting the whole court on the same page.
It's been such a depressing year in general, the court, the whole election season. I feel like we've got to have some kind of optimism. Well,
it does feel, doesn't it, that the fact that they haven't scheduled this case would indicate that there's some real dissension on the court and that perhaps it needs a ninth justice.
Well, that's one theory, is that maybe they're holding off on scheduling the case in the hopes that they will get a ninth justice. That strikes me as a strange strategy, partly because I think it would be, I mean, talk about optimism, the idea that they're going to really, even anytime this term, have a ninth justice. If you think, I think that the Senate has been very clear that there's not going to be movement on the Garland nomination in the lame duck. So you have to wait till January to see who's elected, and then they take office, and then they have to nominate someone and get them through the process. Even in time to sit in April, it requires some serious movement. So I think if the Chief Justice is hoping to get a ninth vote sometime soon, they may have to hold the case till next term. So we'll see what happens with that. And I'm not sure how much, practically speaking, how much discussion has really been going on behind the scenes about a case that's not even on the calendar yet. So it may be that whoever is doing the scheduling is making the same kind of slightly more educated guesses than we are making about how the various justices have voted it. But we'll see.
Nick is going to talk to us next. We'd love to hear some thoughts about the court in general, but also you're going to talk about a specific case, another one that in the last few years groups have tried to get the court interested in, and that's the issue of takings.
Yeah, so thanks. I'm delighted to be here. I'm not sure quite what I'm going to say about the court in general. There's a lot of talk about how the court can't quite really function with 8 justices, and that this moment is somehow a blow to the court's prestige or something. And I think that's a bit overblown. So it's important to remember that the court functions with 8 justices often when there are recusals and things. It's also maybe important to remember that the Judiciary Act of 1789 created a Supreme Court of 6, so fewer than 8, and also an even number, and the framers thought that was just fine. So, I'm not actually that worried that there's, 8 justices for this little moment in time. And, of course, I'd like to see a 9th justice confirmed in due time, but I don't think that this is any sort of cause for alarm in that sense. I think the court will survive this moment. So I'm supposed to talk about this case, Murr v. Wisconsin. And everyone keeps hoping that these takings cases are going to bring some clarity to the law. I think, again, this one is not going to. But the story begins in 1960. The Murrs, this family, they purchase a piece of property on the water in Wisconsin, and then they purchase a few years later the parcel next door. For tax reasons, I guess one of them is put in the name of the parents, the other one is put in the name of their little small business, William Murr Plumbing. He's a plumber and has a little business, and so they have these 2 pieces of property and this sort of lakefront property, and then eventually they give them to their children. One in, I think, 94 and one in 95 or something, 1 year apart. So then the children have both pieces of property, and one of them has a house on it, the other one does not. And the children eventually decide they'd like to sell the one that doesn't have the house on it. And only then do they discover that they can't. They're not allowed to sell that one, and the reason is there's been some intervening changes in zoning laws. And so the zoning now says that a piece of property has to be at least 1 acre in order to develop, and these pieces of property actually are 1.25, but you're supposed to subtract a bunch of things, and so these lots are substandard, apparently, under the new, and this is new circa 1976 zoning laws. But the Murrs were unaware of this. They'd been, enjoying both pieces of property, and now they wanted to sell the second one. And they emphasized in their briefs they'd been thinking of these as 2 separate pieces of property. They'd always had the idea that this was one that they were going to want to sell. But they can't sell it. It turns out it's now substandard because it's too small. and so they can't sell it. It's essentially valueless or almost valueless, they say. The law, so the change in zoning law says that if you have a substandard lot and and you also, the same owner also owns another substandard lot that's next to it, that they merge, so that you can't sell, and then they become a right? These two together would make one standard lot, and then they could sell them together, but they can't sell them separately. And so this seems very unfair to the MERS, and so they are wanting to claim this works a taking, right? They had a piece of property that they thought had this value, and that is lot F, and they can't sell it, so has the state taken their property? Okay, so this case implicates a line of doctrine called regulatory takings, right? Takings clause forbids taking property for public use except with just compensation. And so the easy case, the paradigm case, is when the government literally takes the land, right? Takes ownership of the land. But there's also this line of doctrine about regulatory takings. Sometimes the government passes a rule about the use of your land. And the question is whether those rules can ever amount to a taking. The answer is at least sometimes yes. So if the rules are so intrusive that in fact they basically wipe out all of the economic value of your land, then you get to claim a taking, and the government has to compensate you for that. Okay, so this is regulatory takings doctrine. Now, but here's the problem. Regulatory takings doctrine requires you to have a view about the denominator. Quite what is the parcel of land that we're talking about? So when we say, did it wipe out the whole value of the land, we have to have some view about what the land was, what the denominator is. So from the MERS perspective, they want to think about these as two separate parcels, and the parcel that they can no longer build on or sell, that one, the value's been entirely wiped out. That's the way they would like to think about it. The state, though, says, no. There's one big parcel of land, and as to that one big parcel, we've wiped out maybe a little value for you, but not much value, and certainly not all. You could certainly still have a house there, and you can certainly still, play volleyball on the other patch of land or whatever. And so this is raising the question of the denominator. And from the MERS perspective, this was a very surprising outcome. And so the brief describes kind of sympathetic picture of how surprised they were. The state says they shouldn't have been so surprised. These were on the books even when the land was transferred to them, and they should be, we should presume that they should have known what the state of the law was. So, what the parents should have done really, oh, by the way, there's a grandfather clause. So if the parent, grandfather clause when the zoning law changed. So if the parents had given Lot F or sold Lot F to anybody else, then it would be okay for that other person to build land on it, build a house on it, etc. So the parents made this error, as it were, by giving it to the children, such that there were these now contiguous parcels owned by the same people. Maybe even if they'd kept it in the name of the plumbing company, that might have worked. But so, what they should have done is sold it, as it were, to somebody else and given the money to the children or something. But instead they give the land to the children, and that caused this merger. Okay. The court grants this case because they think, well, okay, here's a very clean, easy case that we ought to be able to figure out. It's just, is this one parcel or two? What's the denominator? It sounds like it ought to be easy. First of all, it's not that easy. But second of all, this is kind of an idiotic inquiry. What's the denominator? Which we're forced to answer because of earlier idiocy in the doctrine. So the problem is this is binary. Right? If we've taken all of your land, then we have to compensate you 100%. But if we've taken only half of the value of your land, we compensate you 0. And so that's why it really matters what the denominator is, right? If the answer were, when we take 50% of the value, we give you 50% of the money, then it wouldn't matter. It'd be the same answer, and so we wouldn't be having this idiotic denominator question. But because we have this binary rule, we have to figure out what is the parcel of land we're talking about. There's no real in-principle way to answer this. Misha Tsaitlin, who was the head of the Georgetown Federalist Society back in the day and is now Solicitor General of Wisconsin, says, yeah, there's not really an in-principle way to answer it, so you should just answer it by reference to state law. And state law says these things have merged, and so that should be the answer for purposes of the takings clause. And I'm afraid that's probably going to win the day. And I'll just tell you, I really enjoyed reading Misha's brief here. He finds time to drop a bunch of totally legally irrelevant footnotes just for sort of flavor. So he gives you a lot of kind of legal history here at the beginning about land use and how these rules developed. He's talking about metes and bounds and things. And he says, footnote 3, in medieval England, the ritual of beating the bounds was of particular importance to defining the boundaries of a parish, manor, or royal forest. These periodical surveys preserved ancient boundaries by, among other methods, requiring young boys to beat a boundary mark with peeled willow wands to impress its location on their memories. To preserve evidence of particular boundaries, the boys themselves were sometimes whipped on the spot in exchange for a fee, it being thought that the impression made on the memory was thus more likely to be lasting. The testimony of boys beaten during these ceremonies was used to settle more than one boundary dispute. Now, I'm sad to say, I read all these briefs, and I found that footnote to be actually the most edifying thing in the case.
Well, I know for one, I'm going to use idiotic inquiry when I talk to my editor next, so I appreciate that. I was also thought, when you were talking about the court at the beginning, I was reminded of Justice Ginsburg's remark this summer. No, not that one. The one where she was asked if 9 was the right number for the court. She said, well, I certainly wouldn't want any more. Tom is going to talk to us about a couple of cases from the business docket.
Thanks so much. While Bob's reaction as a professional was that he would use the lesson derived from Nick's comments with his editors, I was immediately thinking what I would do with my kids.
Yeah, well, that came into my thoughts too.
It's a pleasure to be here. It's always fantastic to be at Federalist Society events. I don't know of an organization that has had a more positive impact on discussion and debate about the law over the past quarter century, and so it's always incredibly informative. On the broader questions of what's going on with the court, I think I have some measure of disagreement, which is always healthy. Carrie is incredibly knowledgeable about how the Senate, and particularly the Republicans in the Senate, are thinking about this, so I give her a lot of deference. My personal guess is that you will see in the end, if Hillary Clinton wins the election, a pivot, a really quick one, in which Senator McConnell says, look, I've always been, as a matter of principle, opposed to moving forward on this, including in the lame duck, and that's my view, but members of my caucus have spoken with me, and their view is to the contrary, and can we confirm him today? That would be really great. I'm not doing anything after lunch. Because, the Republicans have executed an extremely successful political move and not borne significant political costs for it, and they are savvy and not stupid, and the prospect which still hangs over this process that Hillary Clinton would nominate somebody else and somebody much more liberal is out there. And I think they would much, 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 much rather have Merrick Garland than many of the other possible candidates. So I would be, we'll see. But I would actually be surprised if there wasn't, in the event of a Hillary Clinton election, a lame duck confirmation. With respect to the question of whether the Supreme Court will survive, that question seems to answer itself. But, we did have 6 justices a couple hundred years ago, and then we decided that was a really stupid thing to have an even number of justices. And, the institution just doesn't function as well when there are important things that it can't decide, and it seems things that it tries to avoid deciding. So I actually think there's a fairly common view that it's not like the thing's going to collapse. The public isn't going to blame the justices for the fact that there are only 8 of them. It's not their responsibility. But that things operate much better when the court has its full complement of justices in whatever circumstances possible that aren't required by recusal. So as Bob mentioned, I'm going to talk about the business cases, which do have some interesting things in them with respect to that corner of the world, and I'm going to talk about 3 of them briefly. The first is the Shaw case. It involves bank fraud, and then the Salmon case involving insider trading, and then briefly the Apple-Samsung case involving design patents. With respect to Shaw, there's a couple of provisions of the bank fraud statute, and one of them just says you're not going to go out there and defraud banks. And the defendant in this case, Shaw, is like, well, I didn't defraud a bank. I just defrauded the guy whose account it was, so I'm a good guy. And it's basically one of a number of cases, including the insider trading case, where the conduct here is extremely unsavory, and the question is, does it fall within the 4 corners of the federal criminal laws? And this was actually something that Justice Scalia was very active in thinking about and urging the court to dial back on the scope of prosecutorial discretion on a lot of these broadly worded federal criminal statutes. So what he did is there was a guy who had an account at a bank, and then the guy left for Taiwan, and the defendant got access to the bank account, and he moved the money into another account, first his father's account and then to his own. And so he took about $300,000 from somebody else's bank account. The bank itself didn't lose any money because it's protected. It was able to claw back some of the money, and the rest of it was just the depositor's fault. It was his responsibility. So the question is, look, if someone is to try and steal money from somebody's bank account, but there's no proof that they actually tried to get the bank's own money, have they engaged in a scheme to defraud the bank or not? And it's the defendant says, look, there are other provisions of the federal bank fraud statute that talk about property that's under the control of the bank. This isn't a case brought under that provision. I wasn't trying to defraud the bank at all. I didn't care how the bank did. I wasn't, didn't want any of its money. I just wanted to steal from somebody else, so you should let me go free. It is in an era in which the court has been more attentive to the plain text of the statutes, an argument that has a real chance of success, but is obviously an unsavory one, but has consequences for the scope of the bank and wire fraud statutes, which are extremely broad and have very, very broad and significant penalties. The second case, the insider trading case, is called Salmon, and it is a cousin of a series of cases that people have heard a lot about, because the Second Circuit, where a lot of insider trading prosecutions are brought, has cut back on the insider trading laws, and it got a lot of attention. And the government itself attempted to bring this issue to the Supreme Court. This is the question of, okay, in an insider trading prosecution, when the person gives up the insider information, does the ability to bring a prosecution depend on that person having essentially a monetary interest? So here you have a guy who works at Citi. He has access to information about mergers. He gives that information to his brother, who gives it to somebody else who trades on the basis of it. Now, you could say that the tipper has a variety of interests in doing that, including familial relationships. There was somebody who was marrying into somebody else's family, that sort of thing. So he benefited from it. It wasn't that he was just completely agnostic about it and just like posted it on a blog somewhere. He was trying to advance the interests of his family, arguably, but nobody was giving him any money. And certainly the person who ended up getting the information and trading on the basis of it wasn't aware that he had any financial interest in leaking this highly confidential information about the mergers. And the Court of Appeals here said, well, look, he had an interest in doing so. He was gaining something, even if it was non-monetary. And the government's position in defending that prosecution and the Court of Appeals ruling in favor of it says, look, people do things for a lot of reasons. You don't want to have a legal rule that says unless the tipper who has the confidential information gets a check or cash or something like that, you can just engage in all the insider trading you want. But again, it's a legacy of the the court trending in the direction of more narrowly interpreting the federal criminal laws, really hewing very closely to the text, that brings this into question. It's a very, very, very significant case for the government's ability to combat what it perceives as nefarious insider trading, because there are lots of times where the person doesn't get cash for giving up the information. The third case, which I'll describe very briefly, is a case that I'm involved in, full disclosure. It's Apple versus Samsung. It's a part of the smartphone wars between those companies. It's the design patent part of the smartphone wars. And Apple, like Samsung, has a variety of design patents on how things looked. And among other things, for example, Apple has a design patent on the front-facing screen of a smartphone with rounded corners. And a jury found that Samsung had infringed that patent with its own front-facing screen with rounded corners. And so one would think in the ordinary course of most laws that Samsung would then have to pay damages that relate precisely to that infringement, either the profits that Apple lost as a result of the infringement or the profits that Samsung gained. But instead, the legal rule that was applied in the case is that Apple got all the money that is the profit from the sale of the phone entirely. So it went from being, a $5 million case to a $500 million case. And it's a question about the interpretation of the design patent statute, which is can be read and has been read in a variety of different ways. And the purposes behind patent infringement laws, are you trying to really very heavily protect the value of design? Is that what Congress was doing, so that it would apply essentially kind of a nuclear option for damages, so that you would very seriously deter design patent infringement? Or is instead what you're trying to do is compensate the victim of the infringement? And so the court has the ability to pick either of those two views, and there are policy arguments on both sides. But it is most noteworthy for the big number involved, the amount of money, and for the players involved, because Apple and Samsung are obviously fighting about a lot of different things in the context of this technology. But also, design is an increasingly important thing. A lot of things are made by different companies because of how they appear, and consumers are very sensitive to those sorts of things. And so the implications in that sense can be important.
And am I right that the SG yesterday was granted time in that argument? Is
Yes,
that right?
That's right.
So George is going to talk to us about a couple of redistricting cases that are at the court. The court more and more is being pulled into these redistricting cases and having to make decisions. The Chief Justice last term at oral argument didn't seem too pleased, but it's one of those that the court has to make some sort of decision on, and he seemed very worried about the court's role in that. Nonetheless, they have two cases, and in a way it seems like these are racial gerrymandering, but it seems like what we're sort of leading up to is the court having to make a decision on partisan gerrymandering. It's hard to separate out the two of those things right now. So George will discuss those cases.
Well, thanks, Bob. Listening to Nick read that footnote about medieval practices of marking metes and bounds made me very glad that when I worked as a land surveyor in Charlottesville between college and law school, as conservative as I am, things had progressed to a more humane means of marking boundaries. These are great experts up here. I've regretfully never had the opportunity to argue a case before the court, although I've been around a few that mattered. And when Bob mentioned Bush v. Gore, and the court, I was thinking about a Saturday morning when that infamous motorcade of trucks was on its way to Tallahassee full of ballots about to be counted per the Florida Supreme Court's penultimate decision. I had the pleasure of having a conversation with then Governor Bush about the process of getting a stay, when we might get a stay, how those ballots were not going to start to be counted, and things leaking out about what that count was, and so forth. One of the things that I came away from that experience that I now, with a few more years gone by and getting a little older, can appreciate a little bit of cynicism about how the court works sometimes goes a long way. I didn't ask to speak about these redistricting cases, and I did ask to speak about them because I am an expert on redistricting jurisprudence. I'm not. But rather, in the context of these cases, I'd like to speak a little bit about why I think Justice Frankfurter was correct in 1946 when he warned, quote, "Courts ought not to enter the political thicket of redistricting." There's two cases now that are on appeal with the Supreme Court. They came from 3-judge courts, so these do not go through the cert process, but the court notes probable jurisdiction, which they did last June. They're not yet set for argument, although they're on the docket for this term. And as Bob mentioned, both of them center on claims of racial gerrymandering in violation, allegedly in violation of the Equal Protection Clause. And just if you, we don't have time, and nor do I have the expertise to go into this in great depth, but in essence, the difference between a racial gerrymander in the jurisprudence and a partisan gerrymander has to do with why the state legislature, which has constitutional responsibility for federal redistricting, why they did what they did. The first case is McGuire versus Harris, which involves 2 infamous congressional districts in North Carolina that have been the subject of no less than 4 prior Supreme Court decisions. The second case is Bethune-Hill versus Virginia State Board of Elections, in which 12 state legislative districts were challenged as racially gerrymandered, and the court, the 3-judge court, found that one of them, in fact, was, and therefore violated the clause. Both of these raise factual questions of whether, and this is the test, race was a predominant factor in the state legislature's action. Both also present a legal question of whether race can be shown to be the predominant motive for creating a given district when the lines were drawn to, for example, create a majority-minority district so as to satisfy the requirements of the Voting Rights Act, prohibition on diluting minority voting rights or retrogression in the extent of minority voting rights. It's important to also keep in mind that a consideration recognized by the courts under the Voting Rights Act is not just protecting access by minorities to the franchise, but rather ensuring that minority groups are not intentionally denied the opportunity to elect candidates of their choice. I think trying to explain the jurisprudence of racial gerrymandering is an exercise in trying to explain the inexplicable, but I'll give it a shot. The explanation that I found sort of most enlightening comes not from me, but from some commentators who have described the Goldilocks rule. Too much racial motive in setting the size and shape and content of districts can be an equal protection violation. Too little consideration of impact on minority voting rights can cause Voting Rights Act violations to occur. So just the right amount of racial consciousness on the part of the legislature equals a win in deference to the state legislature's constitutional role. This and other aspects of the jurisprudence might be characterized as presenting a muddle of confusion in the middle of Justice Frankfurter's thicket. And he was right that it is a thicket because look at what is happening when legislatures address these redistricting questions. They're making political choices. Those choices are made by political operatives, politicians, and they're made to obtain political advantage. So what should we expect but a thicket of political issues? The jurisprudence, in fact, is very fact-dependent. It seems that legislatures and politicians now have learned the game, and they create a record that's designed to withstand scrutiny, particularly on the partisan side, and I'll come back to that in a minute. I've actually, in looking into this, I was moved to think that if the late George Carlin were to reappear as a legal commentator, he might say something like, "Wow, this is really confusing stuff, man," or perhaps some other word. The well-respected Georgetown Law School Supreme Court Institute has said of these cases in this term, quote, "They offer the court the opportunity to clarify the nature of racial gerrymandering claims." I would respectfully say of this 4-4 court in those cases, good luck. It's equally unlikely, I think, to address a question that Bob at least alluded to see how this 8-member court will take on the political gerrymandering issue, which is even more complicated. It does not seem in this jurisprudence that there is even a consensus on the court as to what constitutional analytic framework that question might even belong. And we could get into this in more depth, and I'll probably get in over my head. But Justice Kennedy has more recently raised the issue of whether, there's a First Amendment aspect to this. This has been looked at in a number of different constitutional contexts in the past, and there's even, I think, a lack of clarity as to whether this is a question of individual rights versus some other kinds of rights when it comes to the way districts are arranged. So I'll close with this observation. Judicial tolerance, rather, of political gerrymandering allows it to be used now as a defense against allegations of racial gerrymandering. In other words, when a racial gerrymandering case like these two comes up, the defense is, oh no, that we're not doing this with any racial motivation or of any sort. I mean, race, we're taking it into account because we must under the Voting Rights Act, but the real reason we're doing this is for political advantage, and a record is made to that effect. It seems clear that safe districts are not only the holy grail of operatives of all political stripe, but also are now irreversibly blessed by the redistricting jurisprudence. So what does that level of acceptance of political gerrymandering do to our body politic? I don't think, and I welcome your comments on this when we get into questions and answers, but I don't believe that the electorate in the United States as a country is anywhere near as divided as are its elective representatives. That is a direct result, in my view, of redistricting practices and the tolerance for creating so-called safe districts. These conditions create even more division on issue, which in turn begets even more extremism in reaction, perhaps even as our choice in the presidential election on this go-around attests. If we are on a course to even greater divisions, it is because our courts, having waded into Justice Frankfurter's thicket of redistricting, seem lost to find an intellectually honest and constitutionally sound path out. Thank you.
Thank you, George. So we can touch a few more bases. I'm going to quickly, so quickly as to probably mangle them, run through 3 criminal cases that are on the docket that are interesting, and then ask for the panel to talk about them. One is Pena Rodriguez v. Colorado that looks at whether or not a defendant right to an impartial juror means that they can go behind the juror's deliberations. And in this case, this defendant was convicted of sexual assault. And after the verdict, 2 jurors went to his lawyers and said there was a bigoted juror. He talked about, of course, he was guilty because Mexicans take what they want, and that he had been in law enforcement and that he'd had a lot of experience with Mexicans before, and seemed to say that is why we know that he's guilty. The Colorado Supreme Court said that his lawyers could not bring that evidence, could not go to a judge with that, and now it's here. Some jurisdictions allow this. The federal rules don't, and other states don't. And so it's a very interesting question. Another along those lines is Buck v. Davis, a death penalty case from Texas. The crime, I believe, was committed in '95, horrible crime where this man killed his girlfriend in front of her children. At his sentencing at his sentencing, there was testimony from a state psychologist that, yes, he would be a future danger, something that Texas law required to show for the death penalty, because he was male and because he was black. There were a number of these cases that all went down. They all got new trials except for this one case. And so it is now at the court on a procedural question, but the issue behind it is what makes it so interesting. And then there is Moore v. Texas, which I think Nick is interested in and will tell us about. And then if anyone has remarks on any of those cases, we'd love to hear them.
Sure. So Moore v. Texas is also a death penalty case, and it concerns the execution of the potential execution of someone who claims to be retarded. So this case is of interest to me because this is building on a case that was decided when I was clerking at the court called Atkins. So in Atkins, the court held that it violates the Cruel and Unusual Punishments Clause to execute a mentally retarded person. And this case concerns the definition, quite who counts, quite who is mentally retarded. Now, I can tell you that, I think without telling tales out of school, I think I can say at least I was aware, I think many were aware, that this was going to be a problem, right? This was going to come up when we were considering Atkins. So, the Cruel and Unusual Punishments Clause, paradigmatically probably was intended to forbid certain kinds of punishments, like, being drawn and quartered or something. But the court has gone down this road of saying that executing certain categories of people is cruel and unusual, even though it wouldn't be cruel and unusual for other categories. So in Atkins, they said executing retarded people was cruel and unusual, but didn't quite define the term. Now, why? It just would have seemed odd, would have felt strange in a way to say, you can't execute anyone with an IQ under 70, or someone who's mentally retarded as defined by the DSM-4 or something. And the reason is, that just doesn't feel like a constitutional rule. That feels legislative. Right? It sort of sounds legislative. Very odd to think that somehow the Eighth Amendment incorporates the DSM-4 or something like that. So the court, instead of saying that, said, the states have discretion to have a certain amount of discretion to figure out quite who counts as retarded and who doesn't. And now the claim in Texas is that Texas is not doing it right. They're looking at a kind of older standard, and science has moved on, and so they should be looking at the DSM-5 or whatever, and should have updated their standards. So this is a sort of problem that the court created in 2002, which is now coming home to roost here.
And a very unusual rule the Texas court has come up with from Of Mice and Men, the Linney rule, and which seems like an odd rule to have in place as well, a fictional character. Any thoughts on any of these cases from the panel?
I talk about the jury deliberation case for a moment. The court has for a long time sort of adhered very closely to the so-called no impeachment rule. A jury verdict deserves finality. That's it. We're not going to go behind that verdict and start looking at imperfections in that part of the criminal process. There's obviously very good reasons for that rule, very good practical reasons. If we were to open up that part of the process to allegations of error, first of all, anyone who has been a trial lawyer or been around trials know juries do a lot of crazy things. If the door were opened to getting into that, lawyers would be bound to try to investigate what took place in the jury room and look for those kinds of mistakes. And the objective of finality would quickly be lost. On the other side of that, though, and this case brings it up, where facts do come out that the imperfection is so egregious that you almost look at it and in that you know it when I see it category can say, this person did not get a fair trial on account of something that did happen in that process. What do you do? The court has, over time, basically adhered to the notion that there are other safeguards than going behind a jury verdict that are designed to catch these kinds of things and fix them, either in the trial process itself or by some other means. But when that hasn't happened and you have this, will the court sort of stay with the rule, with the no impeachment rule, and leave it? I think this is going to be a very, very close one, particularly given the current makeup of the court. My own view is that as harsh as it may be, it's a lot like habeas jurisdiction. If there is any exception, it will have to be an extremely narrow one with a very, very high threshold.
Tom, Carrie?
I'll just comment on the one thing to be looking for in a couple of these death penalty cases is we saw in the Glossop versus Gross case, 2015 case, the dissent by Breyer and Ginsburg kind of basically flagging the issue of maybe we're ready to reconsider the constitutionality of the death penalty whole hog, and I think that's just going to be interesting to watch. I don't think there's the votes for that yet, but I think it will be interesting to see if we continue to see sort of concurrence, dissent, separate writings on that to that effect, and it also makes it another interesting factor in who would that fifth justice be, because we don't really know exactly where Kagan and Sotomayor stand on that question, and who knows who the ninth justice, how that could play into those things. Again, I don't think it's going to come up this term, but you may see this be another of these stepwise, long-running campaigns to make that issue live again.
Tom?
Well, I think the two cases are very interesting for what they will tell us about whether the past, we were past the high water mark for the court's desire to impose procedural restrictions on collaterally attacking death sentences or other criminal convictions. These are cases where the court has become more and more aware of problems involving race in the criminal law, and the idea that jurors could well be biased, or that this guy's own defense lawyer put in an expert report that said that African Americans are more likely to be dangerous, which is like not a good strategy. I'm not a former prosecutor, but I would love to have defense counsel doing that. And I think that the court is going to be hesitant to have the country perceive it as essentially turning a blind eye to these very serious flaws. Now, how, as a matter of principle, they write opinions that say, essentially, this person can get relief, but we're not opening the door to a lot of challenges to jury verdicts is a very, very difficult thing. The only other small thing that's worth noting is that these kinds of cases illustrate why Merrick Garland, for example, might well be different from other Democratic nominees. As a former prosecutor himself who has been attentive to the needs of the government and prosecutions, somebody like him is somebody that the government probably would much prefer to have adjudicating a case like this than kind of a more standard progressive nominee like a Sonia Sotomayor is, I think, quite likely to be much more sympathetic to the defendants.
Mm-hmm.
Just one comment on that, because you mentioned it before as a moderate, but I did want to bring up an article that Adam Liftak had recently talking about a recent study that looked at several of the shortlisters that were perceived for this spot, maybe a next one, and found Garland, interestingly, even to me, to be the most liberal amongst the list. So more so than Patricia Millett, Paul Watford, Jane Kelly, Sri Srinivasan. And so it was just heartening for me to hear that I'm not the only person saying he, in fact, is not as moderate as he has been advertised. I agree. This issue is one that we don't really know exactly how he stands, except for his history as a prosecutor, because there's not death penalty cases coming up before the D.C. Circuit. But just another piece of evidence that I think the idea that he's the most centrist person you're ever going to get isn't actually necessarily borne out. We'll see.
Well, it's great to hear Carrie's support for Sri Srinivasan and Patty Millett on the Supreme Court.
While we're on Merrick Garland, let's say that Secretary Clinton is elected. Give me the odds that we'll see a Justice Garland. Carrie?
Oh, is it if Clinton's elected? Well, I'll give it 10%. I think it's pretty unlikely.
You do?
Even under Clinton, Clinton renominates.
Oh, she renominates him. Well, if she, then I think it's really hard to.
Or you don't think she will renominate him, or you don't think the Senate will move during the lame duck?
Oddly enough, the Clinton transition team hasn't really reached out to me yet, so I'm not really sure what they're going to do in terms of renominating. She's been calculatedly coy on whether she would renominate him. I think that's a good question. I still say very low odds. So.
Nick?
I actually agree with Tom that I think we'd see a quick movement to try to confirm him in the lame duck if that were to happen.
I think Nick's really smart.
I think a lot depends on what also happens with the Senate. If the Senate remains in Republican hands, then I think the possibility of Merrick being confirmed grows. If not, if the Senate were to turn over, I think it's unlikely.
You think she would get pressure to nominate someone else?
Yeah, I mean, she'd at least want to go through the process of considering someone else rather than just accept what's there.
We have more to talk about, but I want to take some questions from you guys, people in the audience. Who would like to go first?
I have a question on the cert process.
Hold on just a second, I think.
Okay. On the cert process, you need 4, and you can only choose from 8 now. And is this possible to actually calculate this the way you can calculate drawing into an inside straight when there's one of your opponents is already showing a 5? Is it simply capable of mathematical? You can say, oh yeah, the math or the statistics tells us that we should expect this. Is that possible?
With a poker reference, I guess Tom goes first.
I think the answer is, look, if you have fewer people who can contribute a vote to granting cert, doesn't that just mean that you've just lost 11% or so odds of getting cert granted in any case? I think the answer is probably no, because there's not an even random distribution of votes. They tend to pack together. So, for example, 4 out of every 5 cases that the Supreme Court agrees to hear involves a circuit conflict. And those votes to grant cert, there may be 8 votes. It's not a case where you're frequently just clawing for the 4th vote. Does it happen? Sure. But increasingly, or in a substantial number of those cases, what you're having is defensive denials anyway. So I think what's probably happening here is that in ideological cases, both the conservatives on the court and the more liberal justices of the court, neither one wants to step into ideological questions for fear of getting a justice of the wrong stripe and not liking the outcome. And that's why you're getting more mechanical cert grants that involve just standard circuit conflicts that are boring. So I think that the justices do tend to pack together in their cert voting, not uniformly, but they tend to, based on whether or not they think they have to hear the case because of a circuit conflict or because they think they can do some good on a question they care about.
Anyone else?
I think there's also, because it's always also an interpersonal thing, there's other strategies. I mean, there's the well-known, courtesy 4th vote. If there's 3 people and it seems like it's a borderline case, okay, sure, I'll give you the 4th vote to take it. So you may see, I'm not sure if you'd see a courtesy third, but I think there could be some of that. There could be some of the justices saying, we have a light load, let's take this case that otherwise wasn't, it's just got a split, but it's got a really narrow split that we wouldn't normally have taken. So I think it maybe will self-correct a little bit that way, but I agree. I think Tom's analysis makes sense as well.
Well, we saw a courtesy fifth in a case that hasn't been accepted yet, so I want to talk to you about that. That's Gloucester v. GG. This is the case of the transgender student in Virginia. And the school board does not want to follow the Fourth Circuit and the district court's ruling that the student has to be allowed to use the bathroom of his choice, of his preferred gender, his chosen gender. The case came for a stay to the Supreme Court, and it was approved with 5 votes, but Justice Breyer said he was only giving the 5th vote as a courtesy to preserve the status quo for now, and seemed to say that that's not going to affect him when the court decides whether or not to take the case. Now, there would already be 4 votes, it appears, from that vote to take that case, but would they really want to take a case in which it was going to be, they knew it would be tied 4-4?
Well, I'll point out that the big legal question in that case, actually, it's an interesting case because the facts are literally sexy in this case, but the question, the legal question, is one that's often not considered very sexy, and that has to do with our deference. It's an administrative law question that actually is a very important question, and one that there was an increasing appetite, it seemed, on the court to really reconsider. This is when you defer not to just an agency's interpretation of a statute that's actually been passed by our elected representatives, but the agency's interpretation of its own regulation. So, and in this case, it was even questionable. It's not even necessarily a regulation so much as a series of letters that went back and forth. It wasn't something that was binding on law. But I think there's a risk in cases like this where there's such a high valence third rail kind of issue involved that the case gets overshadowed by that rather than the actual legal question. And there's a similar legal question, very different case. Also, it's Hyosung DNP, and I think one of your partners is on the brief in that case, which is significantly less sexy in the facts, but actually presents another very interesting our deference issue in that case, where you're deferring to their litigation position on what their regulation should mean. So I think that raises some of the really important questions without having maybe the conflating variables of all of the social issue. But as far as I know, that one's not quite ready to be considered yet. I don't think they've had the response in yet. So it'll be interesting to see if they maybe want to hold this over, and then if they want to look at it might make, if they're hoping to avoid the high salience questions of gender identity, et cetera, maybe they could take a less prominent case that addresses the same question, and they could simply hold that one. Or simply say, the our question is one that has been percolating and moving for a long time. I wouldn't be surprised also if the court just said, the facts in that case in particular are really unique and unusual. This might not be the best case to dig into it, especially because we don't want to have to touch the issue with a potential 4-4.
Although they did stay it, which would show
that's true.
an
That's true.
interest.
So there's that.
Anybody?
Yeah, I would just pause on Justice Breyer's decision to vote and provide the 5th vote that was required to put that lower court ruling on hold. And I think that shows probably 2 things. The first is the justices really are trying to function as a governmental institution and collaborate and cooperate in whatever way possible. They delayed reaching 4-4 decisions until the last minute at the end of the last term, suggesting that they were trying to work some things out maybe. And so I think it's Breyer's signal that he will not, try to let one side be prejudiced by the fact that they don't have a full complement of justices. But the other thing is that I think he could well be playing the long game. Carrie mentioned Justice Breyer's increasing hesitancy about the death penalty, and justices on the left have obviously been more willing to grant stays of execution. I think it may well be that he's trying to navigate to a circumstance in which he looks to the court's right and says there are going to be things that you want stays on, and I will be in a position to provide you a courtesy 5th vote. But if somebody's going to be executed and we really want to take a hard look at this, I expect the same courtesy from you. I don't know that that's actually what's going on or if it'll play out, but it would be the kind of thing that he would do.
Which they had, a term or 2 ago in which a stay of execution was not issued in one of the lethal injection cases. Anybody else on those cases? Who else from the audience has a question? Yes, sir.
Kenneth Jones with Supreme Court Yearbook. As long as they're still on the cert process, I looked it up and was reminded that last year at this time, on the last Thursday before the first Monday, they issued 13 cert grants in one day. I wonder if any of you expect a batch on Thursday, or will we continue to see few cert grants?
Well, they've had their long conference where all of the cert petitions backed up from the summer while they're all off gallivanting in Europe, et cetera, or on their bus touring the country. In the case of Justice Thomas, they get heard this week at the end of September, and then so this is why we see a big jump when they announce the results of that conference. So I expect we will see a big jump. It'll be interesting to see how big that is if they get back on to a similar to their previous pace. I don't know, but we'll see a jump.
Yeah, I don't expect any of them to cause our hearts to go aflutter. But I can tell you from my own personal practice that there are plenty of important, boring questions out there that I think they'll be able to find some things they can love.
Yeah, it's important to remember that there are 8,000 cert petitions, right? And also that the court in the 1980s used to hear 150 cases, and now they're hearing 80. So they can, they really do get to pick and choose, and they can create from these 8,000 cert petitions, they can create a docket of 80 or a docket of 150 or a docket of 40. I mean, they have so much to choose from that they can really do what they want.
Next to Kit.
Yeah, just I guess specifically for Professor Rosenkranz, I'm just curious if the concept of consensual severance is at play at all in Murphy, Wisconsin. I know the plurality and stop the beach renourishment sort of flirted with the idea again, and if there's any possible movement on that.
Yeah, so there's in the Penn Central case, there's this question of the air rights over the Grand Central Terminal, and there's just sort of this idea of can we divide the interest in the land? Can we think of it as different pieces? And then say, well, you've taken all of this one piece. But to me, this is just these are just sort of the flip side of the same coin, as it were. I mean, we can arbitrarily decide on the denominator being just the air rights, or the air rights plus all the other rights in that parcel, or that parcel plus the parcel next door, or every parcel you own worldwide. I mean, the denominator could be any of those things theoretically, and I don't think there's an in-principle answer to this. So it's kind of an unsatisfying inquiry, really.
Anyone? Yes.
A follow-up question for Professor Rosenkranz in regards to the Murr case. When it comes to expanding those sort of denominators as to what can be considered under Lucas takings, do you think that the court would allow that to really expand, especially given the potential implications on agribusiness and farmers around the United States who could be impacted by the decision?
Right. So, so just to clarify, the bigger the denominator, the less likely to find a taking, right? So if the denominator is big, then you'd say the regulation only took a small fraction of your property, and so we're not going to count it as a taking. If the denominator is smaller, then the odds are better that for your takings claim. The court's probably not going to adopt some very expansive view of the denominator, which would thus make takings claims, regulatory takings claims, even harder than they already are. They're quite difficult already. So in Penn Central, for example, they did reject clearly the view that the denominator was every piece of property that the company owned, in New York. That was not the answer. And so whether the answer is this property plus the one next door, that's the kind of small question here. But I don't think you're going to see a kind of dramatic shift or even dramatic clarity in either direction.
Just for fun, I'm curious if the panel would care to speculate on likely retirements given the question of with choosing each of the presidential candidates winning. So likely retirements under Clinton, likely retirements under Trump over the next 4 years.
I'll just have the caveat of even when it seems like politically there might be a logical likely retirement, for example, in the case of Justice Ginsburg during either of President Obama's term, she was getting a lot of push to retire. It doesn't always happen. When I was clerking, it was not long after Justice O'Connor had retired, and I think there was definitely, you got the feeling that she maybe thought she might have pulled the trigger too quickly and would have liked to be on the bench. And I think watching her close friend and colleague go through that may influence Justice Ginsburg a little bit more, especially now that her husband has passed away, and she is really at an unprecedented peak in popularity and renown. It seems like it might be a strange time for her to step down, despite the fact that she is now into her 80s. So I think we have to be, from the outside it's very easy to game out, it might make sense for, her or even Breyer to step down if Clinton wins, and I don't know what Kennedy would do in terms of, you may know more, if he'd feel like he ought to step down during a Republican versus a Democratic president. But I think it's easier for us to game out than it would be for that person to actually make the call to say, you know what, I've had this amazing career and now I'm done. I think that's probably a hard decision for anyone to take, even when it strategically might make sense.
Yeah, these are very sort of personal, idiosyncratic decisions. But so 2 of the justices will be, at the end of the next presidential term, would be 82, and 1 will be 87. So as a sort of actuarial matter, there could easily be another vacancy for whatever reason, or several could happen.
Yeah, I think that probably the perspective of each of the justices is now very widely accepted, that you retire under an ideologically sympathetic president because you think that president is most likely to appoint someone who has a solid view of the law. There's nothing improper about that. I would say that the puzzle of what Justice Kennedy will do is the one that interests me the most. You have a justice who, even in the era of Justice O'Connor, nonetheless played an ideologically central role on the court. And now plays an unbelievably significant role on the court. And if a Democratic nominee comes on and pulls the court materially to the left, that could change. And in particular, if a second Democratic nominee, were to kind of reinforce that was going to be true for a long time, Justice Kennedy has a role in American public intellectual life that I think he probably could foresee doing something else if he thought that his influence on the court was going to be relatively minimal because of the ideological shift of the court. So I think he would at least think about it because he, cares a lot about democracy and likes giving a lot of speeches and talking about the nature of the law and the like. I still think that he, obviously loves the job, is operating at a very high level, but I would be less surprised to see him leave under a Democratic administration than I would have been to see, for example, a Justice Ginsburg or Breyer leave under a Republican one.
George?
My only observation would be that, and I'm not sure this will make any difference to those individuals because they are very individualized decisions, but I would think if, for example, there's a President Clinton, second President Clinton, there will be a tremendous amount of political pressure to allow her to name younger people to the court for a much more lasting influence. Whether or not that'll have any effect, I don't have any insight.
Well, I think it's interesting, too, to keep in mind that if there is a President Clinton and another Democratic appointee to the court, that Justice Ginsburg, for the first time, would be the senior justice in a majority rather than in a minority, with the ability to assign decisions when someone else not senior to her is there. And so, I think she would be reluctant to give that up very quickly. On the other hand, if I believe 2 years from now will be even harder for Democrats to retain a Senate majority, and so that would factor into what kind of nominee President Clinton could put up. Anyone else?
Can I ask each of you, what, if any,
We use microphones,
Yeah, I know. What, can I ask each of you, we've all played the parlor game of what a fifth liberal or quasi-liberal justice would mean for the chief. And, but I wonder if you think it really would change his views. I mean, we always write about him as having the long game in mind. So then what would be his long game? And I'd like each of you to opine on this.
Well, I mean, if Garland or a similarly liberal justice were confirmed to the court, you would go from it. I think regardless of what happens, it's gonna be really interesting, because you would see, for the first time in many decades, a really solid 5-justice liberal coalition on the court. And we see already that the 5 liberal justices vote very consistently together, much more so than the conservative justices and or Justice Kennedy. And so it's interesting it'll be interesting to see, because that really most of the chief's perceived influence has been in trying to bring those two together. Sometimes even playing the swing vote in cases, and I think his ability to do that would be obviously fairly minimal. It could, I think some speculate it would be less the Roberts court and more the Ginsburg court, if that's going to happen. And I think all of the major changes, whether that means overturning Heller, overturning Citizens United, all these different dramatic impacts that people have talked about, those aren't going to be things that I think Roberts would view as would want necessarily to view as his legacy, and I don't think ultimately they would be from his contribution, obviously. So I think we'll have more. We would have more of a Ginsburg court. I don't know where that leaves him, the Chief Justice. I don't think it necessarily would induce him to move to the left. I would sort of hope not, unless he was simply vying for getting to write some of these opinions. But I would hope that may, in some cases, free him up to feel more able to have a more principled position. I think there's sometimes when, from my perspective, it looks like he was allowing some of the desire to build a coalition or please some of the outside audience to switch where I think the more principled position on his vote would have been. And so, when there is no hope to even get that 5th vote, maybe he will hew more closely to a principled constitutionalist line. We'll see.
I guess I'd just say my intuition is I don't think that the chief likes to think about this in these terms. So, many or most cases do not split 5-4 across ideological lines, and I think the chief will continue to think of his job in the same terms, and will continue to think of his job as being a sort of steward for the court as an institution, even if he's going to be in dissent in some of the big ticket, socially, salient cases. He's going to continue to do what he's doing and not think of it as a dramatic change in his job description, I would imagine.
I mean, so there are two models here. William Rehnquist, who was John Roberts' mentor and he clerked for him, really, in the early years of his tenure on the court, was out there in the wilderness and just was willing to, take very principled stands in dissents and separate opinions in the view that someday the law would catch up. And he was largely right. John Roberts would face a different challenge, and that is playing defense, so that he faces the prospect of the legacy of the court's last 25 years being undone. And, I think he'll act with a great deal of principle. I would say that I think that there will be a number of cases in which he will see the wisdom being to go to the more liberal members of the court and saying, we can build a broader coalition if you all want to move relatively slowly. There are two choices for the left. One is to, if it wants to do something like an all-out assault on a case like Citizens United or Heller or something like that, to fight the fight over whether they are being just exercising power and not respecting stare decisis. And justices like Elena Kagan and Merrick Garland, if he would be there, would be very hesitant to kind of invite that kind of criticism. And I think would be susceptible to an approach that says we can resolve case X on a narrow ground that you're inclined to, and we can avoid having just an ideological 5-4 split. And so I think you would see cases like that, so that he would slow down the reversal of a lot of conservative developments in the law strategically, is my guess.
I think it's a really profound question, Nina, and one that's very difficult to answer until you know what the makeup, is it Merrick Garland or is it somebody much more progressive or liberal?
Carrie explains there aren't such people.
Well, maybe. But I do think, it's hard for me to answer that question because, I know John and I worked with him and I have a lot of admiration for him. And as disappointed as I might be in some positions he's taken in some cases. I think John, and I think Tom really hit it, John will put the institutional interests of the court ahead of almost anything, followed probably fairly closely by his natural and understandable and not, I don't say this in a negative way, interest in his own legacy as the Chief Justice. And I think the effect of that would be seeking in as many cases as possible perhaps a middle ground that takes him and maybe one of his conservative colleagues to a position that they might otherwise not want to be, but in the interest of maintaining some consistency in the court's jurisprudence on some of these really hot button issues, and thus, as Tom said, slowing the process down. I think that's John's personality and his approach to work would lead him someplace close to that.
Another question? Well, let me ask, we all have a sense that the court perhaps is not taking some controversial cases or sort of avoiding some that they think that they might be split on. But I think it's a little hard to point to specific cases that we think that they haven't taken because they are split. Does anyone have thoughts on that?
The only one that comes to mind right off the top of my head is the Stormins case. That was the Washington State Conscience Clause case. Had to do with 49 states have the ability, if you're a pharmacist, to refrain from filling a certain prescription if you feel morally opposed to it, and you can refer them to another pharmacist to do so or another pharmacy to do so. And in the case of Washington State, through a very kind of almost explicitly intentional process, this law was changed, and the members of the Board of Pharmacy were even changed in order to achieve eliminating that conscience protection. And in this case, it was the pharmacy involved, the Stormins pharmacy, where within 5 minutes there were something like 30 other pharmacies who could have filled the prescription. In this case, it was for Plan B, so the pharmacist there was opposed to contraceptives that can work as abortifacients in this case after intercourse. So the Ninth Circuit upheld that, and the Supreme Court denied cert on it, and there was Justice Alito had a strong dissent from denial of cert, basically saying if we're not willing to stand up even for religious freedom in a case that's pretty extreme here, where it's obvious they're trying to target conscientious objection specifically, then this is going to be a real problem going forward for religious freedom. So I think that's the kind of case that may have had the additional vote if Justice Scalia had been there. So if nothing but that, I think it's more likely it would have been taken with him on the court still. But I also think it could have been the kind of issue where the court said, oh my gosh, didn't we just do contraception? Let's not go near this again. We don't want to have to try to recobble together another Little Sisters type arrangement. So.
Mm-hmm.
I think that's definitely the best example. I would say that you might well have seen the court more interested in some of the voting cases that have come to it, if there was a sense that with respect to voter ID or other forms of contested restrictions on voting, like early voting and the like, they one side or the other could see getting to a real majority, and they have applied what seems to them to be a principle of not getting involved and not changing the law very close to the election. But a lot of these questions are very close and could be dispositive in the outcome.
Mm-hmm. Texas has now filed for cert in its case. Do you think that the court has to take one of these cases to further define what Crawford meant, a voter ID case?
Yeah, probably so. And I think that that case is being set up so that it's not in the heat of an election that's going on right then. And that's the circumstance I think they'll be most likely to. There isn't lessening interest in the questions of voter identification, and there's a segment of the country and a lot of legislatures that are very concerned about perceived voter fraud, and so this question is not going away. I think that this, Crawford is among the issues that you would say in a new, what we might call a new Supreme Court, if the court were to pivot to the left, could well be redefined in a very significant way. And so a lot of these cases, Justice Scalia was for kind of aggressively moving the court on important questions when there was a more solid conservative majority. And John Roberts' perspective even then was to move kind of more slowly and more modestly, which brought him some conservative criticism. There are a number of issues out there, gun rights being among them, things like Crawford being among them, that are kind of hanging out relatively undefined, and a more liberal Supreme Court majority could, kind of put the kibosh on them in a significant way.
Bob, I'd like to believe that the court will take one of those cases, or maybe more than one, because they present very important questions that are sort of impact a fundamental part of our democratic process. I don't know whether they will or they won't, or what it means. I do think they're staying away from them right now for a reason. I'd like to believe that reason is to sort of let the jurisprudence percolate through the circuits a little bit. But they are really important questions, and what makes them doubly important, and even makes the timeliness of addressing them important, is vote fraud doesn't matter in 90% of all elections. But when it does matter, it really matters. And I know there's a lot of studies that it doesn't really exist and all of that. But when you look at what happens in a very, very close election, and how we've gotten into litigation over close elections, and probably we'll see more, when vote fraud questions start to enter into the mix of issues that might be raised in that litigation, it's going to become even more difficult. And what worries me the most about all that is our people have a genuine belief and faith in the election system, that it works, that actually the people that get the most votes win. And if that faith gets shaken by any means, and certainly the question of whether vote fraud can affect the outcome of election would do that, I think we would be headed in a very bad direction.
All right, that is our time, I'm afraid. Please thank the panel for me. They make my job very easy.